Welcome back to Free Speech Nation. Now, a row over what some are saying is two-tier justice. Ricky Jones has just been acquitted after allegedly urging people to slit the throats of anti-immigration protesters. Yet Lucy Connolly was jailed for 31 months over a single ex-post about setting fire to a migrant hotel, deleted within hours, followed by an apology. Now, the cases aren't exactly the same, different charges, different pleas. But Ricky Jones was granted bail. Lucy Connolly wasn't. And had she been, might she too have fought the case and been acquitted? To discuss whether this is evidence of two-tier justice is criminal barrister and former political advisor Dominic Bardill and top criminal defence lawyer Paul Britton. Welcome to the show. Paul, I'll start with you. When the verdict came out, certainly on social media, everybody went a bit crazy. Everyone was like, this is exactly it. This is two-tier justice. Did you agree with that or not? No,
of course not. I mean, look, anyone that has an involvement in the criminal justice system in this country will know that there's a lot more to it than just that. What you've got in this case is 12 jurors, OK? And they have been selected from at random from our electoral roll. They go into the court. They can be removed. So if there is some bias or some potential conflict, you can remove jurors in this country. So there were 12 jurors that both sides, the prosecution and the defence team, were completely happy with. They've sat there and listened to all of this evidence. We can read newspaper headlines and take little bits out of it. It's completely different to sitting through days and days of evidence. They left. They came to a verdict within 30 minutes. It was super quick. It was persuasive. They were convinced. There was no guilt here. He was innocent and he was acquitted and he walked away. You know, when you start throwing into other aspects like, OK, so he's a counsellor, so what? I mean, that's what we're talking about here. You know, the whole idea of two tiers is that an everyday person who may be a tradesman, a plumber, will be treated differently from someone who's a solicitor or a barrister or a policeman. I think his political leanings. Like, if it had been someone right-wing talking about murdering left-wing people, the argument goes that possibly he was guilty. It's not. And if it was, well, and the Lucy case, I mean, it is very different. I mean, she said she was guilty. She pled guilty. Jurors weren't even involved in that case. Okay. Well, that is the other point of it, because perhaps it's not, Dominic, as clear-cut as all of that, because the focus has kind of been pushed onto why Lucy Connolly wasn't given bail, even though she had a child at home and a sick husband.
It's very, very difficult to work out, just from watching from the outside, why she wasn't given bail. There's three reasons why you don't get given bail. You're going to commit further offences, you're not going to show up to court, or you're going to interfere with witnesses. Now, in this kind of case, I can't think of why a childminder from a certain background who's never been in trouble before would do any of those three things. So I can't say why, because I just simply don't know the thinking of the judge that denied her bail. It may well have had an impact on how she had dealt with the case. When I represent clients, it is significantly easier to deal with the case when you've got them on bail. You can meet with them when you want, they can speak to their family members whenever they want, they can prepare their case. So I think there is something to be said for perhaps Lucy Connolly, maybe, and I am speculating because I just simply don't know, I wasn't there, but there's something to be said for Lucy Connolly, perhaps, I imagine, just based on my impressions of other clients that I've represented, being completely overwhelmed while she's in the prison system and perhaps wanting out very quickly. Now, I'm saying that, speculating, I don't know. I have to be clear about that. But what it does show, what the Ricky Jones result shows, I think, is actually something quite different from a two-tier system, per se. I think what it shows is that when people go in front of juries with crimes or accused of crimes that are related to speech, juries do not want to acquit them. And one example I'll give you is a man called Mark Heath in my home county, Leicestershire, who was involved in a similar trial to Lucy Connolly, accused of the same thing.
Did you say not want to acquit them or do want to?
Don't want. Do want. Sorry, I got that wrong. Yeah, that's not good, is it? Do want to acquit. Don't want to convict them of speech-related offences. Now, contrast that, in fact, with, and I always get his name wrong, so I'm going to say the gentleman who did the protest outside the Turkish embassy.
Yes.
Now, contrast that. He had a judge-only trial. OK, and that judge appears in the judgment to have relied on someone attacking him as evidence that he must have caused them alarm and stress. That's outrageous and ludicrous, but that was the thinking of this judge. That's what happens when you go in front of a judge. When Mark Heath in Leicester Crown Court, based in Loughborough, went in front of a jury charged with a similar or same offence as Lucy Connolly, not guilty he went, and the jury acquitted him. And this is the city of Leicester, which is very, very mixed in terms of racial demographics. So what does it tell you? It tells you that ordinary people don't like condemning people, even for saying things that are not pleasant. But those people who run our systems, those people who govern us, have a very, very different perspective. That's your two tiers. That's your two tiers.
And one of the ramifications of this would be, Paul, that anybody who is committed of a similar crime would hold out for a jury trial. Now, if that was to happen, wouldn't the system break down? If you can't trust the plea
I mean, the only good point, I know you got a round of applause at the end there, but the only good point that you actually made is that if Lucy had defended herself and wanted to run her case to the end...
She would have got not guilty.
She would have got not guilty.
Definitely.
So, I mean, that's just even a more salient point that you can't compare the two cases, because she capitulated and gave in.
But isn't the point, one of the first things you were talking about, is this reason why she wasn't given bail? Because I don't understand. That's what I don't understand.
You can't speculate there. We haven't seen the bail application.
There was a political...
There are reasons why... No, I mean, Dominic set out the 3 reasons why you don't get bail. You do get 2 chances at bail. So I don't know why her defence team... Look, I don't know...
I mean, I'm just saying there was a lot politically going on at the time where the government seemed to be very invested in coming down heavily on people who they saw as committing these kind of crimes.
OK, well, that kind of segues into Keir Starmer's silence over all of this. And, you know, I always say that the government shouldn't tread into judiciary territory anyway. So I think Keir Starmer has done the right thing. I think he shouldn't have said anything. Suspension was the right course of action and was suspended within a few days. Kept his mouth shut, was right to keep his mouth shut.
But he didn't keep his mouth shut at the top, though, did he?
Well, what makes you say that?
Well, I just mean he came out and said that anybody who was committing these kind of crimes was
No, that's not what he said.
No,
that's not what he said. He said that, you know, when he was campaigning, he said that, you know, criminals will feel the full force of the law. They will be prosecuted, they will be tried, and they'll be punished. That's very different to this case, where you're innocent until proven guilty. And I think the people in the audience here would absolutely agree that you are. And what we can't have is a system where we are judged by our tabloid headlines. You know, I actually feel for him. I feel for Lucy. You know, had I been her lawyer, I would have said, look, you're not guilty. You're plainly not guilty. Ricky has got off because, Mr Jones has got off because there was no intention, you know, under Section 45, which is what he was charged under, you have to have an intention to compel someone to commit an offence. He says, well, what I said wasn't aimed, and actually Section 45 is a little bit more diluted because it leans on belief, doesn't it, rather than the actual mental element, which we call the mens rea. So I think it was the right outcome. I don't think we've got 2-tier justice in this country. Everybody in this country suffers the same legal framework. It goes through the same process. We have a right to be judged by our peers, and our peers are the jury that are randomly selected. I don't know how you can get any more fair than that.
Well, I don't think you can necessarily get more fair than the jury system, but it has been tinkered with. It's been tinkered with even in my lifetime. Things like majority verdicts. For centuries in this country, we had the view, and we still do, that you need 12 peers in good standing to find you guilty of a crime. Now, of course, if they take a bit too long, the judge can give them a majority direction, can't he? And he say, well, actually, now we'll take 10.
Well, so otherwise it frustrates the justice system.
It doesn't, no.
You can't have a jury out for weeks and weeks.
What you have is the person walks into a courtroom innocent of whatever they're accused of until the jury say otherwise. And if the jury haven't said guilty, then the default position should be innocent. That is innocent until proven guilty. Not, well, it's halfway hung jury, we'll have a retrial. Oh, well, we'll take 10. Oh, well, we'll move the goalposts. Because all that does is it allows people in certain positions to move the goalposts when it suits them, when they want to move the goalposts.
Well, Snaresbrook Crown Court has got a backlog to 2029.
Absolutely. And I've appeared there many times.
Yeah, I couldn't criticise the process of majority verdicts.
Oh, I do. I absolutely criticise. I don't think that they should exist.
But Paul, going back to this point, is that if the lesson that comes out from what happened here is that everybody should contest contest the charge, go to court, but be before a jury, then don't you think there is a problem there in that now that's going to add even more cases? Like we already have this huge backlog.
No, look, that would fetter justice because everyone has a right to a fair trial. So and a trial, you can't just have a judge saying, OK, guilty or not guilty. Although, I understand the arguments for judge-led trials in the Crown Court at the moment, but I worry that it's a slippery slope into that becoming the norm. And which,
what do you think about the fact that they're talking about cutting down on jury trials?
I'm against it at the moment. Yeah.
Even though that may create more of a
what the country should do is invest in our justice system. People want to have faith in the justice system. We have around 90...
You guys want to get more money?
Well, yeah.
No, I agree with you. I'm joking.
Yeah. I mean, we have roughly 90,000 prison cells, for example, in this country. And, we've got about 3,000 vacant at any one time. And we're really right near the edge. Crown courts, as Dominic will know, they're in disrepair. They're falling apart. They are not nice places. Hospitals are nicer places.
That's right, yeah.
There needs to be some sort of respect paid to the judicial system in itself, especially the infrastructure, from the ground up.
Donny, do you think that there are people who, they're not lawyers and barristers and solicitors, they just see the results of happening here? They've seen a mum go to jail over a tweet and they've seen someone...
But she did say she was guilty.
No, I understand that, but do you understand... But can you see why there is a feeling of two-tier justice?
Yes.
It's just in the results here.
Now,
people have seen with their own eyes... I can understand the legal thing here, and he is innocent. But do you understand? Would you say?
I can appreciate where people are coming from. I don't actually think, in the strict sense that everybody says it, that there's a two-tier system in the courts. I think that that's not quite the case yet. I think that there are multiple tiers in policing, in prosecution decisions, because very often prosecution decisions made by the CPS and the police will be based on policy rather than... So, for example, I've had many cases where I've sat in a court and I've been having discussions with the prosecutor and we were both of the view there's not enough evidence here to proceed. So they have to, a lot of people don't realise this, but the prosecutor has to phone up somebody at the CPS and ask their permission to drop it. This is a fully qualified barrister. And he phones up a lawyer in an office and says, can I please drop this case? I mean, I'm slightly shortening it. And they very often turn around and go, no, because it's a knife crime, so you've got to continue. Well, it might be a knife crime, but both of us are of the view that there's not enough evidence to continue. You've got to continue. If this person is going to be let down, it essentially is the attitude, let the jury let them down, not the CPS, not the police. And that is entirely political. That's not based on any legal decisions. I'm not suggesting that the CPS don't make a legal decision as well. There has to be something there to begin with. But what happens is we, I think, as lawyers, barristers and solicitors, have a responsibility to translate what's happening in our courts for the average Joe in the street who isn't in the court every day and doesn't always understand what's going on. If we don't, can we blame them for reaching their own conclusions? I don't think we can. So I think in the court, yes, people are generally treated, once they're in court, the same way. But actually there is a problem with the way that we get to court in the first place. If you take, for example, Ricky Jones and Lucy Connolly, they were charged with different offences. And although the circumstances were slightly different, they could have been charged with the same offence. It just so happens that Ricky Jones's is more difficult to prove than Lucy Connolly's. And that, again, some people, and I've heard people saying this, I don't suggest it's my view, but some people would suggest that that is a sign of two-tier policing or two-tier prosecution. Now, it might not be, but if we just sit there and say, no, that's just ridiculous, don't be ridiculous, and don't actually engage in a discussion and explain and educate people, or accept when they're making a point, then is justice actually being seen to be done? And, of course, we're going back to our law degree. Part of our constitution is justice must not just be done, it must be seen to be done. And the question here is it being seen to be done? And the only people that decide that are the public, not the lawyers. Is the point
there not the consistency with these offences? I mean, two offences that could have been the same, and what you're saying is that the CPS should be more consistent in its approach to these offences.
Well, look, I just know that next time I'm in trouble, I'm going to hire both of you. Big round of applause, please, for criminal barrister, former political advisor Dominic Bardill, criminal defence lawyer Paul Britton. Next on Free Speech Nation, editor of an independent literary magazine claims he's been blacklisted by the left. Find out more in a couple of minutes. See you then.